It's no surprise to say that personal injury law and personal injury lawyers are not the most favored people or favored things in our society. I'm proud of what I do, however, and I don't feel the stereotype or the cliche fits me or many of my colleagues. And in discussing the Harambe gorilla case and that frightening incident in the Cincinnati Zoo, perhaps I can suggest to you that not all events where there is an injury or potential injury will make out a case, will be a case. And let me give you an example from that. First of all, thank God, the child wasn't really injured. The child may have some sort of psychological effects from that frightening incident, but at least there was not a significant, as far as I know, physical injury. But let's assume, just for the sake of a discussion, an academic discussion or whatever, that the child did sustain a significant physical injury and indeed had as well psychological injuries. Let's evaluate the liability of that case. There are some things, surprisingly, that may not be known that would suggest that there could be some liability on the zoo. The child was able to climb up on a 3-foot high fence. In the fence, it was not like a solid wall, but rather had metal bars across horizontally, such that the child could put his little feet in sneakers and climb up and over. That's not the best way of fencing in a dangerous animal, I suggest. And secondly, there was what we call a subsequent remedial repair. The fence is now 3.5 feet high. So that's some evidence that we would like to say as plaintiffs of negligence. And although that evidence can't come in for negligence, you can usually get it in a case for feasibility purposes or impeachment purposes that something better could have been in place. The zoo also had some issues with polar bears just a few months before, and I'm not sure, to be candid, of the connection necessarily if it just meant that the zoo had been negligent or lax in its security overall. If you could somehow tie it in and somehow make it a nexus to the incident that happened with the child and the gorilla, those polar bear incidents may well be another tool in the plaintiff's lawyer's arsenal in proving or trying to prove negligence. But one thing bears in mind, and I've mentioned this in prior blogs dealing with injuries to children, and that is anytime that is litigated, the defendant, in this case, for purposes of our discussion, the zoo, could try to third party in, that is, make as an additional defendant the parents. And they would argue that the parents or whomever was watching the child was negligent in the supervision of the child. And I have to say that perhaps that might resonate in this case. So in answer to the very beginning of this blog about personal injury lawyers and the perception of personal injury law, no, not all cases would I take. No, not all cases would respectable and serious lawyers take. And if this case came to me, even with significant injuries, I might well hesitate, particularly because I think it might lend itself to a strong argument that the parents were negligent in their supervision of the child, even though the zoo, perhaps, arguably, could have done better. Thank you.